On this video, I'm going to break down exactly what you need to know about Ohio's new wholesale regulation so you can stay compliant and follow the law. I'll even give you the exact disclosure you need to use on every deal. So if you wholesale in Ohio, pay close attention to this video coming up.
This video is brought to you by the 100% Funding System, a program where Jerry Norton funds 100% of your deals with his money. To learn more, go to usejerryscash.com.
My name is Jerry Norton. I'm the wholesale industry's leading authority on all things regulation. I maintain a free report with all of the different regulations by state. You can download the latest version at wholesaleregulations.com. As of this recording, SB 155 passed both the House and the Senate and is awaiting the signature of the governor. Now, because the effective date is not specified in the bill, it likely falls into one of two scenarios, common in Ohio bills. The law will take effect 90 days after the General Assembly adjourns, which would be March 1st, 2026, or the law will take effect on the date signed by the governor, which could happen any day. Now, once I find out, I'll pin in the comment section the date it goes into effect for you. Okay, first, let's take a close look at how Ohio defines wholesaling. It says, a wholesaler is defined as a person or entity that for a fee, commission, or other valuable consideration enters into a purchase contract for residential real property and assigns or novates that contract to another person or entity. So it's clear here that wholesaling includes assignments and novations. Then it says the following: a wholesaler may act in place of a grantee, purchaser, or grantor, seller of the residential real property. However, the bill's notice requirements apply only to wholesalers acting in place of the purchaser. So what does this mean? Well, the bill recognizes that sometimes a wholesaler might act as the purchaser or grantee. That's when you put a property under contract and then assign or novate the purchase contract to another buyer. Or you might be acting as the seller or grantor. Now that happens when a wholesaler already holds a contract to buy a property and then enters into a separate agreement to sell it to another party before closing. We call that a double closing. So the law recognizes that a wholesaler could be operating from either position as the person buying or selling the property's interest. So when it says the bill's notice requirements only apply to wholesalers acting in place of the purchaser, it's limiting the mandatory disclosure rules to wholesalers who are acting as the buyer. That means if you are a wholesaler putting a property under contract with a seller, you must give all the required disclosures, which we'll talk about in a minute, so keep watching. But if you're acting as the seller, for example, reselling in a double close or assigning to an end buyer, the disclosure obligations do not apply. In short, there are specific disclosures that have to be made to the seller, but not the buyer. Okay, so what are these new mandatory disclosures? Let's talk about it, but first, let me give some context. The Ohio Senate explained that these disclosures are to protect the consumer. The Senate said that the wholesaling model has had issues with targeting vulnerable homeowners, predatory contracts, and misleading sale tactics. This new law frames that failing to disclose properly is a deceptive act under the Ohio Consumer Sales Practices Act. Guys, I've been saying this for years. If you intend to wholesale, you have to be honest and explain to sellers what you're doing. So let's talk about these required disclosures now. There are 5 things that a seller must agree to in writing in 12-point font before contracting a property. 1, the buyer is a wholesaler and does not represent the seller or owner. 2, the wholesaler intends to assign or novate the contract for a profit. 3, the wholesaler may charge a fee to a third-party buyer. 4, the purchase price may be below fair market value. And 5, the owner is advised to seek legal counsel. And just in case you're wondering, the wholesaler cannot modify or waive these disclosure requirements. And it does appear that it needs to be a separate document and not buried somewhere in your purchase and sale agreement. Now, as of this recording, there is no official state-published standardized form that shows the exact language the seller must sign. Maybe they'll come out with something, so I went ahead and drafted my own disclosure, and I'll give this to you for free to download if you want it. I'll put the link in the description below for you. But let me read it to you right now so that you know exactly how this is supposed to read. It says, I, undersigned, hereby disclose that I am acting as a real estate wholesaler and do not represent you, the property owner, as a real estate broker, agent, or fiduciary. I intend to enter into a purchase contract to buy your property and may assign, transfer, or sell my rights under the contract to another buyer for a profit. If I assign the contract, I may receive a fee, profit, or other compensation from the buyer who purchases the property from me and through my assignment of the contract. The purchase price offered to you may be below market value. You are encouraged to consult with an attorney or licensed real estate professional before signing any contract to sell your property. You understand that once you sign the purchase contract, it may be assigned to another party without your further consent. If this disclosure is not provided and signed before entering into the purchase contract, you, the seller, have the right to cancel the contract at any time prior to closing and retain any earnest money within 30 days of cancellation. And then both parties sign. Okay, so what are the repercussions if you don't properly disclose? Well, if the wholesaler fails to make the required disclosures, the property owner can cancel the contract at any time before escrow or closing without penalty. Now, if that were to happen, any earnest money paid by the wholesaler must be dispersed to the seller. Okay, furthermore, the wholesaler may be subject to disciplinary action by the state regulator, including $2,500 per violation. Now, there are a few things worth noting here. First, this law does not require a real estate license like many other states have required. And what about a double closing? Do you have to disclose to a seller when you're double closing? And the answer is no. In a double closing transaction, you are not assigning or novating the original purchase contract. Therefore, you are not technically acting as a wholesaler under the bill's definition. By the way, this is the very reason why I started offering transactional funding for double closings. I have a special program where we'll fund your first double closing for free and then lock you in at a discounted rate for all your future transactions. So next, I want you to watch this video right here where you'll get all the details about that program, and I'll see you on the next video.